Welcome to episode 2 of my video training course. In my last video I explained the basics about the pre-examination. In today's episode I want to explain a bit more how the pre-examination looks like and how you have to deal with it. This will be based on the pre-examination of 2016, so if you want to solve it first on your own, then you should stop the video now and come back to it later. As I said already in my last video, the pre-examination comprises 20 questions, which again comprise 4 statements each, totaling up in 80 statements. Of those 20 questions, the first 10 relate to legal knowledge, and the second 10, the questions 11 to 20, relate to the analysis of claims. Let's start with part 1, meaning the questions pertaining to legal knowledge. I will take question 1 of paper 2016 as the example here. You see, the first 10 questions always comprise a small facts of a case section, so to speak, and then the 4 statements follow later on. Let us read the fact section first. Opposition proceedings are pending against all claims of European Patent EPB. The only ground of opposition is Article 100C EPC. Today, the 29th of February 2016, the EPO receives third-party observations against EPB. The submissions of the third-party observation are as follows. It is explained that prior art document D1 anticipates claim 1 of EPB, and it is reasoned that the invention in EPB is not sufficiently disclosed. Now, what comes into your mind when reading these facts of the case? I spot immediately some keywords which get me thinking. For example, opposition proceedings. Of course, you think immediately of the legislative text describing the opposition procedure. You also may think of the different grounds of opposition as outlined in Article 100 EPC. The next thing which grabs my attention is that the only ground on which the opposition seems to be based is Article 100C. What is this article about? Right, extension of subject matter. The next thing which catches my eye is the third-party observation, which was filed against EPB. What article do you have to think about immediately when it comes to TPOs? Right, it's Article 115 EPC. Of course, you also can have a look at the guidelines, and you also at that stage might want to think about the difficulty of introducing new grounds of opposition, because the third-party observation obviously introduces new grounds of opposition. And here are the grounds highlighted. What are they actually? Here it says a prior art document anticipates a claim, and this is of course nothing else than a ground for opposition according to Article 100A. And the second grounds of opposition is that it is reasoned that invention is not sufficiently disclosed, and that of course is based on Article 100B. So those things should go through your mind when you look at the different sections of the case as such. And now we will look at the statements and how to answer them. Let's come to the first statement of question 1. The first sentence here is just to remind us that we have to fill out the answer sheet, whether the statement is true or false. And the first statement reads, since third-party observations can only be filed concerning issues arising under Articles 52 to 57 EPC, the opposition division will not consider the reasoning concerning lack of sufficiency of disclosure. Well, let us hang on for a minute and just ask our common legal sense whether this can be true or not. Is it conceivable that the TPO is restricted just to the articles 52 to 57? So basically the grounds pertaining to Article 100A? Well, maybe this statement kind of tries to tackle the problem that introducing fresh grounds for opposition after the expiry of the opposition period is not a straightforward thing, especially not for the opponent. And its admission in the end depends really on the discretion and decisions of the opposition division. However, again, looking here at the third-party observation, which normally is only filed after the expiry of the opposition period, it would be quite unfair, so to speak, if the third party would be kind of prima facie restricted to the grounds for opposition referred to by the opponent or to the grounds just outlined in Article 100A and not the other grounds. However, well, it might well be that later on the opposition division still decides not to consider some of the arguments raised in a third-party observation because they are maybe far-fetched or something, but at least it should be possible for the third party to raise those arguments in the first place. So, already by these considerations, you can tell that this statement probably is wrong, but of course it is better if you can answer this question directly based on some articles or rules. And that is the case here with Article 115 EPC, which says third-party observations may be directed to patentability in the broad sense. So there's no restriction to some certain articles or certain grounds of opposition. So this statement is wrong. Let's go to the next statement, statement 2. It reads, the submission of the third party will be forwarded by the EPO to the patent proprietor. Well, if you know the proceedings before the EPO a little bit, you will know that pretty much everything is forwarded to the parties of the proceedings. And of course, there's a good reason for that. I mean, each party needs to know which arguments and evidences are part of the proceedings so that they can react in the right way to it. But again, it's better to know the legal basis for that. And Rule 114.2 EPC reads, third-party observations are communicated to the proprietor. So this statement is correct. Next statement. This statement reads, the submissions of the third party will be accessible to the public through file inspection. Again, pretty much everything is put into the public file inspection, one can say. I mean, the few exceptions pertain to information which needs to be kept confidential for some really important reason. However, in those cases, the party needs to explicitly request this and provide evidence also why certain information needs to be excluded from file inspection, and then still the opposition division will decide on that. So it's kind of the default way, if you like, that any document is put into the public file inspection, as long as I said, there's no exception. So there's no reason to believe that third-party observations may be handled differently. And let us check the legal basis for that. It says in Article 128, subsection 4, third-party observations become part of the file and are accessible to the public. And again, you can also look into the guidelines for more explanations. So that is a clear answer here, and of course then this statement is correct as well. Let's come to the final statement, number 4, which reads, the opposition division is allowed to introduce into the proceedings lack of novelty with respect to claim 1 as a fresh ground for opposition. Well, I touched on this a little bit already when we talked about statement 1. It is within the discretion of the opposition division to introduce or allow fresh grounds of opposition to the proceedings, if, of course, they make sense. So maybe a prima facie relevant document which is filed later, but is still, as I said, prima facie important, can be accepted and introduced by the opposition division to the opposition proceedings. And this is based on Article 114.1 EPC, and there's also a G decision to that, 9 out of 91, which basically says the opposition division can introduce a fresh ground for opposition into the proceedings. So this statement is true. So that was question 1. So you have to fill out your answer sheet with wrong, true, true, true. And then you are done with question 1. Let's have a more general view on part 1. What type of questions can you expect in general? Well, you are already in the lucky situation that there have been already quite some pre-examinations. So the only thing you need to do is to go through them, the recent exams, and try to find out what type of questions are asked there. However, I tried a little bit to do that for you already. And what I found is that one focus of the questions is within kind of procedural questions, if you like, in a broad sense. So questions pertaining to prosecution, grant procedure, opposition, appeal, TPO filings. For example, I would consider this question number 1, which we just solved, as some kind of procedural question. Another emphasis lies on deadline calculations. I mean, there is a reason why you have a calendar in the annex to the pre-examination paper. So you will have to calculate deadlines at one point on your own, and you need then to check if the statement is true or false with respect to that deadline calculation. Hand in hand with that goes often some questions with respect to fees. Here you need to know which fees apply, when, and also the circumstances when a fee reduction or extra fee may apply. For example, you can think of processes like further processing or re-establishment of rights, but also with respect to translation and such things. Another topic which sometimes comes up is so-called corrections of errors. For example, what happens if an inventor has not been named, or an error in a sequence filing, stuff like that. A representation before the EPO is also important, especially the question who can do which procedural steps before the EPO with and without representation. Novelty is sometimes a topic for a question, although novelty and amendment step is dealt with more in detail in part 2 of the pre-examination, but still you may find some questions to that. And sometimes you will also find some questions with respect to language of proceedings and translations, maybe, as I said, combined with fee reduction questions, for example. When you prepare for part 1 of the pre-examination, you will anyway go through all of those questions. And so it's always a good idea to, when you do that, to identify the types of questions which are asked there. And you should also try, after you have answered the specific questions, to look kind of left and right of the questions to understand the general legal concept behind those, so that you get really a broader sense of the different topics which can come up. Because, I mean, the questions which will be asked in the pre-examination, of course, will differ from the ones you will have in the older examinations. But so that's why it's necessary to understand the general concept and read the general decisions which somehow make sense in this respect. Let's go now to part 2 of the pre-examination. As I said in the beginning, part 2 pertains to claim analysis questions. That means you will get a number of documents which you have to analyze and then to check whether the statements given are true or false. And that is already the biggest difference maybe between part 1 and 2, that you get the documents. For example, in the pre-exam of 2016, it was a kind of application, I would say, like 2 sets of claims then, and 4 prior art documents, which were just provided to you. And I would dedicate like 10 minutes or so for reading those applications and the prior art documents, if there are any, and kind of try to understand generally what the invention and the story is about. Maybe it is the important message here is, don't let yourself get confused by the large amount of information and don't get lost too much in the details and lose too much time reading that. It's really more to get a general idea of the concept, because luckily you can use then later the statements to guide you through the jungle of information, so to speak. So you can then, as I said, use the statements to as a starting point which documents you actually have to look at in what detail. However, what I would do already in the phase of reading or the first reading of the documents is to label the figures, especially if you have so many as, for example, in the 2016 paper. What I mean is you should put the respective feature already to the reference number in the respective figures, as I've done here, for example, for figure 1, so that immediately when I look at the figure and, for example, see, I don't know, the skirt section, that this is reference number 40, and I have immediately a much better idea, which features are where in the figures. Because later on, when you have to do comparison between the figures and, for example, the claims, it is much easier to compare those with each other when you have done this little work ahead of time. We'll come to that in a second. If you want to be even more complete, you could also put the paragraphs where you found the description of the different features either next to the feature itself or at the bottom, as I did here, at least the general section in the document where you can find the description of the whole figure 1. I would do the latter, because if you put the paragraph next to each feature and it takes too much time, it might be that you lose too much time in doing that. Yeah, depends really how quick you read, how quick you write, how quick you can do all these things. You have to train that for yourself and check out if maybe within the given time you might well be able to write the paragraphs also to it. And that of course helps you even more if, for example, you need some more information about the lid, that you can jump directly to, I don't know, paragraph 6, for example, where the lid explained in more detail, and read a bit more about that. But the description is also not so long, on the other hand, that you can't find it later on. So it really depends a bit also on your personal taste, what you prefer. Okay, now let's start with the real thing, with the claim analysis. So when you have done the reading, you start with the claim analysis. And as I said, you will get then 4 statements which refer back to the documents you just got. And normally it works like that you have several documents which you have to compare, maybe a question, then a figure, then a claim set, and also maybe parts of the description to solve the whole question, respectively, the statement. And that means you should kind of have the documents and figures neatly sorted in a folder-like structure. So in an ideal world, you can grab directly to the section where you want what you want to get. For example, figure 3, I don't know, and document 2, and question number 14, and I don't know what. Yeah, so just make sure that you have some kind of sorting system where you can easily get those documents which you need just for solving this statement, and all the rest of the documents is stored in a way that you easily can access it when you need it. Let's have a look at the first statement of question 11. It reads, the subject matter of claim 1.1 excludes a system that comprises a container with a pouring zone. And I have also written down here already claim 1 for you, which reads, a system comprising a container and a lid for closing the container, wherein the lid has at least 2 perforations of the same size. And the keyword here is really that you have, on one hand, comprising in the claim, which is a kind of open wording. So it defines which things at least have to be there or present in the system, to be part of the claim, being a container and a lid with certain features. But comprising, as it is such an open wording, does not exclude the presence of a pouring zone or a container with a pouring zone. And therefore, any container in the end, with or without pouring zone, is encompassed, of course, in the system. So the statement is wrong. And that was quite easy. That was, the first statement of the first question. So they started here a bit easy, I would say. Let's go to the second statement of question 11. It says, a saucepan as shown in figure 1 falls within the scope of claim 1.2. And here we have to be a bit more careful already. Claim 2 is dependent on claim 1. So in the end, the scope of claim 1.2 is defined by, of course, all the features of claim 1 plus the features of claim 2. So we have to read them together. And we have to look at figure 1, which might look like that after you have noted down, as I said, all the features next to the reference numbers. And you can see now how helpful it is if you have done this, because then you can compare directly by looking at the feature and at the figure and the claims, which features are fulfilled. And then the next thing you just have to do is go through the claim or the claims by feature. So first of all, we have a system. Okay, that's very general. That's not really an excluding feature, comprising a container. So we need a container. A container is depicted in figure 1 as with the number 70. So we have a container actually there. Then a lid. So we need also a lid, which is depicted with reference number 50, also there, which closes the container. Well, one could check in the text if it really closes the container, but I think from the figure you can already tell that the lid closes the container. Wherein the lid has at least 2 perforations. Well, we see some perforations there in this 45 straining section. So their perforations are there, yeah, and there are more than 2. Of the same size. Well, that's something we don't know exactly from a picture. It seems like they are all of the same size, but that is something we might have to check in the description just to make sure. But let's go on first. Then in claim 2, we need additionally that the lid comprises a skirt. That's also there. It's the reference number 40. So skirt is there. And set perforations being arranged in the skirt. So again, we look again, where's the skirt 40? So it seems it goes all around the lid or the bottom of the lid, and the straining section 45 with the perforations is within the skirt. So the only open feature still is the perforations if they have the same size. And for that we jump to paragraph 5. Maybe you have already written next to straining section that the straining section is explained further in paragraph 5 in the description, and there you will find the sentence: the perforations are all of the same size and are dimensioned such as to allow liquid to pass through them. But the information here, and the important information, is that they are all of the same size. So here we can tell now from the picture and a little bit from the description that all the features are fulfilled, and the saucepan as shown in figure 1 actually really falls within the scope of claim 1.2. So the statement is right. Let's go to the third statement of question 11, which reads: a saucepan as shown in figure 2 now, falls within the scope of claim 1.2. So in the end we have to do the same thing as we did just before, but with figure 2. Here it's a more simplified version, so I haven't written down all the features next to the reference numbers, but of course you could still do that. The important thing here is that the pot or the saucepan pretty much looks the same like in figure 1. However, the lid looks a bit different, and there is the skirt section which is still there, reference number 40, but it is like has like kind of protrusions, or how you want to call it. So it's not a full skirt around the lid, but it's like, has these 4 areas where it is broader, and other areas which is really, really thin, with the reference number 53 actually. And there's now the question if these perforations of the straining section are actually still within the skirt section, or if that is some other part of the lid. And for that, of course, we have to go back into the description of figure 2, and there we will find in paragraph 11 that the skirt, reference number 40, comprise a ring 53, that's what we saw already, and 4 protrusions 45, and down protrusion is the straining section 45. And then from there we know that the perforations are the same size, etc., as we have checked out for figure 1 already. So we can say, okay, these features are also all fulfilled in claim 1 and 2, and figure 2, or the saucepan of figure 2, falls also within that claim. So the statement is right as well. Let's come to the last statement of question 11, and that's a bit more tricky. It reads: a lid for closing a container, wherein the lid has a knob and at least 2 perforations of the same size, falls within the scope of claim 1.1. And now we read again claim 1 as a reminder. A system comprising a container and a lid for closing the container, etc., etc., etc. The important thing here is that we have the keyword "and." So the system, which is claimed in claim 1, is defined by comprising at least, one could add, a container and a lid. So at least one container and one lid. Could be more, but at least you have to have a container and a lid. And now the lid, which is described in a statement, it's a lid for closing a container. So it's suitable for closing a container, but it doesn't pertain to a system or a combination of a lid and a container. And claim 1, as it is written there, kind of limits itself to a system which includes also a container. So a lid without a container does not fall within the scope of claim 1.1. And therefore, this statement is wrong. So by this last statement, you can already tell that you need some more time to be invested here, and you do have to do some thinking really to come up with the right solution, whether the statement is wrong or true or wrong. So that's a good example that for part 1 or many questions in part 1, you will have to do some comparison between different documents. As we saw, figures with claims, maybe different claims with each other, maybe prior art documents with figures or the description and those kind of things. And this is all quite time consuming as compared to the questions of part 1, because in part 1, the questions you either know them or you don't, and that's the important thing, you can prepare much better for the questions of part 1, because they are all legal questions which you can look up before and read in the comments, etc. Whereas for the questions of part 2, you have to develop the solution within the examination itself. And that's the reason why I recommend that you should invest for the part 1 questions about 8 minutes for each question, so 2 minutes per statement. Whereas for part 2, you should invest something like 14 minutes or so per question. And of course, you can try it out yourself, what works best for you, but that's how you should do it. Okay, now what general type of questions you have to expect in part 2? Of course, you will need to assess or analyze the scope of claims. That means you have to compare different documents with each other, for example, claims versus figures. You will have to judge certain wordings in the claims, like comprising versus consisting of, or combination inventions versus single parts of a combination invention. A little bit like we had in our example with the lid versus the system comprising a container and a lid. Then general versus specific features might be a role, maybe even ranges which are included somehow in claims, those kind of things. Clarity might be an issue which sometimes comes up. Novelty is something which is discussed, of course, then related to the specific case and the specific prior art you have been provided with, and then you have to judge basically if a claim is novel in the light of D2, for example. And Article 123.2 issues might come up. Not so often, but sometimes that might happen. And then I would say a rather big block is dedicated to inventive step in the broader sense. So questions to technical effect, distinguishing features, problem solution approach, also how to define the closest prior art, to how to define the objective problem, questions with respect to obviousness. So those kind of questions. And well, my call for action for today is try to solve some of the previous pre-examinations under real conditions. That is important. That means that you should use only the allowed resources and utilities, and you need to put yourself under the time constraint of 4 hours. And then after you have solved that, and after you have done the correction phase, basically where you looked through which statements you have answered correctly and which you haven't, then you should do another round where you do kind of like extra reading. So look left and right of each question, also of those questions which you have solved correctly, and try to understand generally the full scope of each question. Because the exact same question and statement, of course, won't repeat and won't come back in future pre-examinations, but the general idea, the general type of questions, of course, will come up again. And if you understand in what directions the questions go, basically, then you can develop your own training, what you need to know to solve even upcoming questions in the future in the pre-examination. Well, and that's for today. If you enjoyed this video, leave a thumbs up or a comment or something, and I would be happy if you could tune in to the next video where I will deal with paper A of the EQE. Good luck and bye-bye.